Very good evening, my dear friends. Actually, the legal protection to bankers has been put into 3 episodes. One is legal protection available to the paying banker. The other one is legal protection available to the collecting banker. And now this episode, the law on dishonor of payments by the banker. What is the legal protection available to the banker and the law thereon on the banker dishonoring payments? Under what circumstances the banker can dishonor and what circumstances a dishonor which is not justified will entice the banker with appropriate liability. So friends, today's episode we will discuss about the law on dishonor of payments by a banker. Basically, the banker is entitled to get protection under law subject to his fulfillment of various legal requirements, which has been already covered in earlier 2 episodes. The banker basically is not supposed to refuse payments as provided under Section 31 of the Negotiable Instruments Act. An exception is that this statutory duty is exempted under certain circumstances if the payment is made under those circumstances. Then the banker would be fastened with a liability to compensate the customers. So what happens? He cannot basically refuse to make payment under Section 31. This statutory duty is exempted under certain circumstances. And if payment is made under certain circumstances which are not supposed to be, in fact, empowering the banker to refuse payment, or where the banker is not supposed to make payment but made payment, then the banker would be fastened with a liability to compensate the customers. How it goes on? That means the banker where should not refuse, refused, or where should refuse but made payments. This is where the liability comes into picture. So one such episode is, instance is that the countermanding of payment by the drawer. A check is an unconditional order of a drawer to the banker, and the drawer is entitled to cancel such an order at any time before the payment is made. So before that, he can countermand. This is called countermanding of the payment by the drawer. The right to countermand is vested with its drawer only. So the proper universal practice is that the order to stop payment must be given in writing to the banker, and it should be signed and properly acknowledged by the banker. And then the customer care services center can take oral instructions also on proper proof of identification. But this is subject to proof under the Evidence Act, Indian Evidence Act. So the banker is liable to the drawer if he pays the check, even by oversight after duly it is notified about the countermanding, that is after receipt of the countermanding order. Now the second point, the death of the drawer. The banker must stop payment of the checks signed by his customers on receipt of reliable information about the death of the customer, as the relationship between the bank and bank's customer ceases on the death of the customer. Solomon writes, says that on the death of a person, all his rights cease, all his transactions cease. Absolutely, no more transactions could take place. In that event, if different accounts are operated in different branches, notice of death must be intimated to each branch separately, independently. The Supreme Court has dealt with this matter in United Bank of India versus Srimati Kanan Baladevi and others. It was reported in All India Reporter 1987, Supreme Court, 1510 page, where the Supreme Court here held that once the banker comes to know about the death of his customer, he should keep the account in suspense until the legal representatives produce proper proof to succeed to the account, like a succession certificate or a probate of a will or a letter of administration, or of course now nomination, and making payment in accordance with the said certificate or any other court order, the banker is discharged from his liability, then he is fully protected under law. So this is another important aspect. Now the third point, insolvency of the drawer. In case of, what is insolvency? Insolvency is a civil debt. The person who is declared as insolvent is unable to pay his debts. Not that liabilities are more than assets. Liabilities may be more than assets. The question is that he is unable to pay the debts. So in this case, in case of insolvency of any account holder, or the partner of a partnership firm, or a joint account holder or in case of bankruptcy of a partnership firm, or in case of liquidation of an incorporated company, the entire power of administration of the bank accounts is vested in the court, and the court directs the official receiver to take over, and then he is called official receiver or official assignee, or in case of a company, official liquidator, as the case may be, and then they would be acting under the instructions of the court. So earlier, the insolvency of a person was covered under the provisions of the Presidency Towns Insolvency Act or the Provincial Insolvency Act, and today a new act has come, which is called the IBC, the Insolvency and Bankruptcy Code, 2016, which has to be read with the Indian Partnership Act or the Companies Act, as the case may be, or even with regard to the cooperative societies, the relevant Cooperative Societies Act, state or central. Then the banker has to follow all these relevant provisions of these particular legislations. Then the fourth one, the customer turning insane. That's called insanity of the customer. So if the banker receives a confirmed information from any authorized person about the insanity of the customer, then the banker can refuse payment of the customer's checks. And then if any dispute arises, then you will have to wait for the order of the court. Now the last point is 5. The justified refusal of payment of checks by a banker. Where the banker is justified in refusing payment of checks of his customers, where it is a case of a post-dated check or a stale check or a wrong drawing of checks, or there is a material alteration, there is found to be a forgery, or there are insufficient funds, or the signature is inconsistent, or there is a garnish order, or there is a proof of breach of trust, defective title of the party, or notice of assignment of credit balance, as enshrined under Section 130 of the Transfer of Property Act, 1882, and such kind of things. So under such circumstances, the paying and collecting banks must follow the circulars, guidelines, orders of the Reserve Bank of India here, which is salutary, binding. It's a mandate. The paying bankers, without any delay, must convey to the collecting bankers the information about the dishonored checks, instruments, and must send them to the collecting bankers. And the collecting bankers must, without any further delay, bring to the notice of their customers about the dishonor of the instruments. Otherwise, the banks would not get any statutory protection. And then, today, in the present day situation, most of the banks send SMS alerts to the customers about the dishonor of the instruments, in fact. So these are all the things, friends, basically we had to discuss. I have just taken a peripheral view. You can go to the depth of the subject. You read Tannen, for example, and then Varshney. I already suggested. With this background, we conclude our discussion on the legal protection available to the bankers. So we will further continue our discussion with RBI, its functions and other things, and basics of Negotiable Instrument Act. In 6 episodes probably we will be completing our syllabus. Thank you very much. Wish you all the best. Goodbye. Good night. Thank you.